All right, grab your notes. Let's work through this together. So today we're digging into good faith, specifically what good faith means when parties are performing a contract. This is one of those topics that can feel a little abstract at first, but once it clicks, a lot of contract fact patterns start making way more sense. So at a basic level, when we talk about good faith, we're really talking about fairness in how parties carry out their agreement. Even if a contract gives someone discretion, the law expects them to use that discretion honestly, and not in a way that basically undercuts the whole deal. You'll see the concept of good faith pop up in a few places in contract law. For example, in requirements contracts, where a buyer agrees to purchase all the goods they need from one seller, and in output contracts, where a seller agrees to sell everything they produce to one buyer. In both situations, the key idea is that the parties have to act in good faith when deciding the quantities. So one can't suddenly demand to produce amounts that are way out of line with what the parties originally expected. The concept of good faith also comes up when we're looking at contract modifications, specifically under the UCC. Under common law contracts, we usually need new consideration to modify a contract. But under the UCC, a contract for the sale of goods can be modified without new consideration, and as long as the modification is made in good faith. So clearly, good faith is doing a lot of heavy lifting in contract law. So what is good faith when it comes to parties performing a contract? All right, first up is the case Goldberg 168-05 v. Levy. In this case, Levy ran a men's clothing store and signed a 10-year lease with the landlord. Part of the rent wasn't just a flat number. Levy also agreed to pay 10% of his gross sales as rent. But the lease had an escape clause that allowed Levy to cancel the lease if his sales dropped below a certain level. At the end of the 7th year of the lease, Levy wanted out. But how was Levy going to get out of this lease? He remembered the escape clause, but he had one problem. It only lets him out of the lease if his sales drop below a certain level. But if he keeps operating the store, then his sales will continue. So Levy has a brilliant idea. If I shut down the store, then there can't be any sales. With no sales, the escape clause is activated. Voila, I'm out of my lease. And that's what he did. He closed the store and there were no sales, and he activated that escape clause. Well, landlord Goldberg was not happy, and he sued Levy for breach of contract. But Levy's defense was, I didn't breach anything. The lease said I could get out of the contract if I didn't meet the minimum sales. And I didn't, so case closed. But the court basically said, look, every contract includes an implied covenant of good faith performance. In this case, because the rent was tied to sales, Levy had an obligation to make reasonable efforts to keep the business operating. He couldn't deliberately wind things down just to trigger the escape clause. In other words, in trying to frustrate the purposes of the contract, Levy acted in bad faith in performing his obligation under the lease, and the court sided with the landlord. Now compare that with another case, Mutual Life Insurance v. Tailored Woman. Similar setup. Again, we have a clothing business and a percentage rent. But here, the tenant later leased additional space under a separate agreement that didn't include percentage rent, and the tenant moved a profitable department into new space, thereby reducing the landlord's rent under the original lease. The landlord claimed bad faith, but this time the court ruled in favor of the tenant. Why? And it sounds like the same thing in Goldberg 168-05 v. Levy, right? Well, not exactly. The court said the difference here was that the tenant was doing something the contract actually allowed. Well, at least something the contract didn't forbid. The court said that if the landlord wanted limits on how merchandise could be moved, those limits need to be written into the contract. The court wasn't going to add new obligations on the parties after the fact. So if we take a step back and look at both cases together, here's the key thing to remember. The implied covenant of good faith requires reasonable efforts in performance, but it does not create new duties the parties never agreed to. The distinction shows up a lot on exams. Another way courts describe this is that bad faith performance is when one party unfairly frustrates the purpose of the contract and deprives the other party of the benefit they reasonably expected. If you can spot this on a fact pattern, you're in good shape. Now, turning to the UCC, good faith in performance is also required, but here we actually get a definition. Under the UCC, good faith means honesty in fact plus observance of reasonable commercial standards. It's still a bit vague, but the UCC adds a key distinction from common law good faith performance: reasonable commercial standards versus reasonable efforts. The UCC looks at what is reasonable in the industry, rather than just what a reasonable party would do. One last thing to keep in mind: the implied covenant of good faith and fair dealing cannot be waived. However, The parties can set standards for performance, but those standards can't be manifestly unreasonable. Alright, that's a big picture on good faith performance in contract law. If it still feels a little fuzzy, don't worry. It really starts to click once you see it in fact patterns. We'll keep working through it though. Alright, back to studying.